Why don't you do it properly? Use your teeth, that would be better.
I'll sue you in court for strict liability.
Can you? I don't think you can. Let me ask my lawyer.
Do you think KP will be sued in a court of law for strict liability by that electricity worker? Well, answer for yourself in the comment box after watching this video clip. Hi everyone, this is Aditya Shekhar, lead mentor for Get Set Law, and today we'll be discussing no-fault liability. As a general rule, the plaintiff is held responsible for all their negligence and all the damages caused to the defendant. However, there are cases in which plaintiffs are held responsible without any fault of theirs. The rule in which the plaintiff is held responsible without any fault of theirs is simply rule of no-fault liability. Now, no-fault liability can be further broken into two parts: strict liability and absolute liability. The principle of strict liability was introduced by Justice Blackburn in 1868 in the case of Rylance versus Fletcher. Interestingly, in this case, the defendant constructed a reservoir with the help of independent contractor to get some electricity for their mill. In the process of the construction of reservoir, the independent contractors witnessed some mine shafts. Now, after the water was filled in the reservoir, the mine shaft exploded, causing damage to a neighbor, which was Ryland. Ryland went and filed a case against Fletcher, stating that it was his responsibility to take care of whatever is there in his land. Fletcher took the defense that he had absolutely no clue of what was there inside the land, and therefore he should not be punished. Now, Justice Blackburn stated that the rule of law is that if a person, for his own benefit, brings a dangerous object in their premises, if the object escapes, the damage caused will be directly attributed to the person who is bringing the dangerous object. So in Rylance versus Fletcher, there were three ingredients which were established as a basic rule of strict liability. The first ingredient being dangerous object. The second ingredient being escape causing damage. The third ingredient being non-natural use of land. When I talk about a dangerous object, noxious fumes, electricity plant, water reservoir, all of them are considered to be a dangerous object. When I talk about non-natural use of land, it basically means an increased danger brought by the usage of land. So for instance, extraction of electricity from water reservoir, that will be a non-natural use of land. Supply of gas, electricity wire in household, running of water for domestic purposes, all of it is natural use of land. And the third ingredient, of course, is escape causing further damage. So these are the three ingredients which are supposed to be kept in mind when I am applying the rule of strict liability. Now, there are certain exceptions to the rule of strict liability. Act of God, act of statutory authority, plaintiff's own fault, things which are done for the common benefit of both the plaintiff and defendant, very well come within the ambit of exceptions. So these exceptions can be basically taken by the defendant to escape liability. Now, the concept of strict liability, as discussed, contains three ingredients. Now, interestingly, one of these exceptions were pleaded as ground to escape liability in the case of MC Mehta versus Union of India. This case basically witnessed leakage of oleum gas, which led to death of few people in Delhi. Now, this case was the case in which the Supreme Court laid the foundation to the rule of absolute liability. Speaking of absolute liability simply means strict liability without exceptions. So here, in case an enterprise is involved in an inherently dangerous activity, they will be held responsible? Absolutely. Now, Shriram Food Fertilizers, they took a plea, they took an exception which has been enunciated in strict liability. The court held that in the present case, they cannot take it as the case is extremely dangerous. Supreme Court laid the foundation to this principle, witnessing the need to evolve law. In this case, Justice P.N. Bhagwati said that law needs to keep evolving according to the needs of society and changes of social structure. Therefore, he said enterprises which are involved inherently in dangerous activities should not be given any exceptions to become absolutely responsible for an act which causes damage. Now, there are certain differences when I talk about the two concepts. Absolute liability makes a person or an enterprise responsible absolutely. There are no exceptions in the rule of absolute liability. Strict liability, although, makes a person responsible strictly, but has some exceptions in it. In absolute liability, the escape is not necessary. The incident might have happened in the premises. The incident might have happened outside the premises. In strict liability, escape of the dangerous object is extremely essential. Now, the damages given in absolute liability are exemplary in nature. The Supreme Court in the Bhopal gas tragedy case gave exemplary damages to the victims of Union Carbide Corporation gas leakage case. In case of strict liability, the damages which are given are compensatory in nature. So these were the three differences between strict and absolute liability. So this was the basic concept of no-fault liability, in which a person is held responsible without any fault of theirs. Meaning, even if the person is not negligent, they are still responsible if they have brought a dangerous object in their premises, the dangerous object has escaped and the escape has caused further damages.